Hello, I'm Brandon McGee, owner of the McGee Law Firm. We focus our practice exclusively on estate planning and elder law. We are based in Southlake and Fort Worth, Texas. And what I want to do is take a few moments here to address some common questions that a lot of people have, questions that I hear from my clients, from friends, from family members, from people in the public who I encounter. And the question that we're going to talk about right now is, what kind of medical documents should I have with estate planning? What are the important medical documents? And my answer to that is there are three of them. Documents that we call powers of attorney. There is a healthcare power of attorney, there is a Hippa Release form, and there is what we call a living will that can also be called an advance directive to physician. So let's back up here and talk about each one of these. The purpose of the healthcare power of attorney is if you become mentally incapacitated, meaning a doctor has determined that you cannot make rational decisions for yourself. You are appointing somebody ahead of time that would step in that circumstance and make your medical decisions for you. This oftentimes is a trusted family member, very close friend, somebody who you think can do a good job making your medical decisions, from the very small ones to the very large ones. Second document, and one that works with the healthcare power of attorney, is going to be a Hippa Release form. That is an acronym, HIPPA. A number of years ago, it became required by federal law to get the medical records of another person. That person has to have signed this form authorizing the release of the records to the person requesting them. So even if you're a healthcare power of attorney, you still need the Hippa Release form if you want to, for example, go if it's your spouse and they're in the hospital and they're incapacitated. If you want to go and get a second opinion from a doctor at another hospital or within another healthcare system, you need Hippa to get the records to take to that doctor or to that hospital. Third document is commonly called a living will, although I prefer advance directive to physician. That's simply where we're predetermining matters of life support. So if somebody is on life support in certain dire situations, such as they've lost the ability to function as a person, and there's been enough brain damage that the doctors believe that they're never going to regain that ability to function as a person and to care for themselves. That's one circumstance. Another circumstance is the individual, the doctors believe that that individual is going to pass away in the near future, even if they remain on life support. So basically we have somebody who either, regardless of what the doctors do, they're going to pass away, they're going to stay mentally incapacitated for their entire life. You can be elected in those circumstances to be removed or to be kept on. And if you make this election, either way, you're taking this decision making out of the hands of your family. Some people prefer that because they feel like they'll put their family in an emotionally very difficult position if they're having to decide matters of life support, or they feel their family members may argue with the person who's making the decision. So those are the three documents that we recommend that all of our clients have. It's important to know as well that we recommend about every 5 to 6 years that our clients update these documents and get new ones, as the laws can change in this area. But I would like to encourage all of you guys watching this video, if you're interested in these documents, then please feel free to contact us, make an appointment to see me. The first consultation is always going to be complimentary, so we will not charge you for that first consultation and to come in and have a conversation. So I encourage you guys to make that appointment.